that's in their discretion. I do remember that. Now, we've learned that if you do an OUIL and child endangerment alcohol charge, it prohibits you from getting an interlock device. We've got a guy in sobriety court right now who's doing absolutely great, and he can't get an interlock. So what they were doing back then was taking an OUIL and then a child abuse neglect charge, which wouldn't affect your driving privileges. I listened to the video, or Laura did. We never actually excused you as counsel. One option, we'll have to reset it unless the prosecutor simply recharges it as civil infractions. If there are civil infractions, he wouldn't be entitled to court-appointed counsel or a jury trial. But we'll cross that bridge when we get to it. But have you had any success in getting in contact with him?
I'm pretty sure that I called and left a voicemail. I didn't, nobody picked up, but I was, from my memory, able to leave a voicemail. So hopefully he'll get notice that, you know, he doesn't have to appear next week, I guess.
All right, well, we'll see how that plays out.
I don't know if I'll be here that day, but I guess.
Well, all right, you don't need to come all the way over here on the off chance that he'll show up, because we won't be doing it. But Angelique, I talked to Jordan. She tells me that you two have been working on her case, and
Yes.
you and Tim have been working on his case.
Yes.
So thank you very much.
You're welcome.
All right, Miss Wallers-Penner, would you come up, please? Good afternoon.
Good afternoon.
Are you Tracy Ellen Wallers-Penner?
I am.
Of course, I know you, but I have to identify you for the record. You're here with your lawyer, Jordan Harden. Also present is Angelique Camfield from the prosecuting attorney's office. This case alleges a domestic assault that allegedly occurred in October on the 18th involving your daughter. The matter is set for what's called a final pretrial here today. Ms. Camfield, what's the status here?
It's my understanding after speaking with Ms. Harden that the defendant's going to enter a plea of guilty as charged. There will be no deferral.
That's what you just told me.
If necessary, I'm willing to do a no contest.
Well, let me talk about this, Ms. Wallers. Domestic assault is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. If you plead no contest, you have to take your gum out.
Oh, sorry.
There's a clean.
I meant to before.
You don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. And I would get the factual basis from the police report or affidavit of probable cause or something else. Do you understand that?
I do.
And are you going to plead no contest to this charge?
Your Honor, we had spoken in the hallway with what Ms. Camfield indicated to me she was planning to recommend to the court as far as a sanction. My client indicated she had no issue with the probation if ordered. I don't know if I guess I don't know where she got the understanding that she wouldn't have to enter any kind of plea today to get on probation. So the offer is you plead guilty or no contest to the domestic violence charge. The prosecutor has indicated to me they're going to make a recommendation for probation with some deferred jail time and some potential treatment for substance abuse, alcohol abuse of that nature. So that's the offer today. If you choose to accept it, we'd enter the plea today, come back at a later date for sentencing, make our argument, provide any evidence we wanted to the court to try to mitigate your sentence. If not, then we leave the matter on for jury trial.
Okay, so it doesn't make a difference if I say guilty or no contest?
No contest, correct. Yeah, no contest if you don't have a clear memory of what happened.
I will enter that plea, no contest.
You will plead no contest?
Yes.
All right, let me ask you a couple things. Did anybody threaten you to get you to plead to this?
No.
Promise anything?
Nope.
Do you understand that if you do plead to this charge, no contest, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that? There will be no trial if you plead no contest.
I understand what you're saying. I didn't know that that was the same as guilty.
Well, it results in a conviction and then a sentence where I could put you on probation. But I don't have authority to do anything to you unless there's a conviction, either by plea of guilty, conviction at trial, or a plea of no contest. So if you do plead no contest, there won't be a trial. Do you
Okay.
understand?
Yeah, okay.
Or if you had a trial, Miss Harden would be there with you through every step of it. You'd also have a right to hire a lawyer of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not have a right to testify and did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. Understand?
Mhm.
A man named Mr. Rhodes was here last month and then earlier this week, and he told me, you don't look people in the eye enough. He said, you're always looking at the damn screen. And I guess I'm guilty as charged. So I've been trying to, instead of looking at the screen over here, looking at the actual people. And so, Mr. Rhodes, I'm trying to do better, looking people in the eye. All right. There is an affidavit of probable cause in here, Ms. Wallers, and I saw it and my heart sank. Your daughter Brielle says that you had assaulted her. Her mother was very drunk and her mother came in and yelling at her, asking for smokes. And then there was an argument and you pulled her hair, and then some other struggle, and you fell on the couch and it was unpleasant all the way around. But that's a sufficient factual basis for me. Is that acceptable to you, Ms. Campfield?
Yes, Your Honor.
Jordan?
Yes, Your Honor.
That affidavit was prepared by Sergeant Jeremy Marsh of the Sturgis Police Department.
And Your Honor, I could just put, I believe the affidavit would reflect that this happened on October 18th, 2025 within the county of St. Joseph.
Yes, thank you.
Thank you. I would make it a little bit of an unusual request. Because the defendant is on bond and not supposed to be drinking or using any illicit drugs, she does have an extremely severe alcohol dependency. After this particular incident, when they located her, she was at a 0.32 blood alcohol level. And I've received information from the family that subsequent to that, she was also found unresponsive at home, and when taken to the hospital, had a blood alcohol of 0.57.
Oh my, 0.57?
So that most likely why she was unresponsive would have been most assuredly alcohol poisoning at that point.
That's the highest
I would
level
like
I've
her
ever seen.
tested today.
I don't have anybody to do it. She'll have to either go to Three Rivers. Autumn's not here today.
Darn.
She's at a training conference,
Okay.
and she's the only one certified to take a sample. Are you?
Just PBTs.
All right. Well, we could do a PBT.
That would be, if that's what we can do, that
Now,
I'll take.
I know Miss Waller, and I know that she was in my sobriety court program. And I spent a lot of time with her. She's an intelligent woman, and that was a few years ago, maybe 8 or more.
It was like.
How long have it been since you relapsed?
Oh, it's just been within this last year.
So you've been sober for 6 years?
15. Was it 2015,
Well, I can look at-
2016? And so 6 years, something like that.
Let's get a PBT. Do you have one here?
I can check.
I think we do. Probation has one. If anybody knows where anything is after the flood. So I know that you can be sober, but this is like danger zone.
Your Honor, if I may request the court also, I think this is one of those occasions where we would need a PSI for a domestic violence charge of this nature.
All right, I'm not opposed to that. Who is Bill Hack to you?
My stepfather,
From the appliance store?
mhm.
I've known him for years and years and years. Are you employed?
I am not currently
Where were you employed?
at Meyer.
As I said, when I knew you, you were a very intelligent, capable person when we got you sober. The law requires that I adjourn the matter at least 10 days to provide notice for the complaining witness to be here. The problem is if I do a pre-sentence investigation report, it's going to take longer than 10 days to do that. There's a no contact provision. Who's out of the house?
Riel,
So you're in your own house and she's staying somewhere else.
she's with her aunt, yes.
Who else is at your house?
Her father, Stephen Penner,
And she's your stepdaughter?
biological.
Biological daughter, okay.
My understanding is the no contact is no assaultive.
Yeah. They
Well,
met-
let's take a look.
That's what the bond conditions I have reflect.
All right, well, let's see. Struggles, no contact entered. As victim is 17, they lived in the same house since the incident, no problems.
Right, the
So-
pretrial release shows provision.
So
R.
there is not a no contact provision, and somebody went the extra mile to let me know why they called it that way. So the conditions you do have personally appear for every hearing, abide by any judgment, do not commit any crime while released, make reports as directed, do not use alcohol or controlled substances, do not purchase or possess a firearm, do not have any assaultive behavior against this person who is a minor. But there is not a no contact provision. But the fact that she's probably staying somewhere else. The problem is that when you have an addiction to this extent, when the judge says, don't drink anymore, you can't just turn it off like a switch. Your body's screaming for alcohol. And so you need to do something about it. Are you in any sort of treatment right now?
I am looking to start some counseling, but I've also had a huge medical mystery that we finally just got solved, and I started treatment for it 2 days ago.
Well, I'm considering medically assisted treatment for you. But do we have a PBT here?
We do not, but we could call Centerville Constantine if you wanted us to do
Would you
that.
please?
Yes.
Tab, do we know where probation's PBT is? We got flooded downstairs and probation is in the wind. One probation aide, they're working remotely till we get their new office space ready across the street. Um, well, let's pick a date for the sentence. I'm pleased we were able to resolve this. But at one time, you were active in AA, you had a sponsor, you had individual treatment.
Kev says it's still downstairs, but it hasn't been calibrated in a long time.
And none of the three, nobody knows how to use it, so. All right, we'll get some assist here. That's our benchmark. Shana gets that.
Thank you.
Thank you. Tracy, I've heard stories of very high blood alcohol levels like that. They had something in Detroit they called the 700 Club. The people that had a BAC, but they were all deceased. That was in their autopsy. And that's generally where 5.7 is. It's in an autopsy report.
Well, and Your Honor, I would just state that's, hearsay that's been provided to the prosecutor. We don't
Yeah,
have any
it
kind of
isn't
verified
evidence in
proof.
this case, but it's frightening. Now, the prosecutors declined to do a deferral in this case. I don't know if you had a previous domestic violence, but I can only do the deferral if the prosecutor consents.
Dispatch is having something to sign.
All right.
Take care of that for us.
So today is February 26th. Jordan, are you available Monday, March 30th at 10:30?
Yes, I should be able to make that work.
Anyway, you know how to go to an AA meeting.
Oh, yeah.
When's the last time you went to one?
It's been a while, but I had gone 15 years straight. Unfortunately, my sponsor died. So,
The common denominator in sobriety court people that relapse is continuing to, or failing to stay in AA.
and part of it, Your Honor, was I was the lead in bakery, and I could work from 6 a.m. till whatever, or noon to 8:30. And we weren't getting our schedule till a couple days before the new week. So even making a doctor's appointment was almost impossible.
All right.
It was
Well,
very difficult to have a
My
reliable
hope for
schedule.
you was that you would have been somebody else's sponsor. Did you sponsor others while you were in?
I helped others. I wouldn't say I officially sponsored them. I was dealing with, work and Brielle and
I believe your previous probation officer was Gina Wagner. She was excellent, but she's no longer with us.
can I comment that the other charge that they say I have
Let's take
was from that 2015 DUI?
3. All right, let's take a look.
The basis for not offering the deferral was that
Oh,
OWI conviction had
Well-
tag along child abuse
oh,
with it.
well, that's in their discretion. I do remember that. Now, we've learned that if you do an OUIL and child endangerment alcohol charge, it prohibits you from getting an interlock device. We've got a guy in sobriety court right now who's doing absolutely great, and he can't get an interlock. So what they were doing back then was taking an OUIL and then a child abuse neglect charge, which wouldn't affect your driving privileges. So if you get the motor vehicle charge under 257 with a child in the car, they will not allow you to get a restricted driver's license with an interlock, even if you're in sobriety court. And we knew this a long time ago, and we've known it for a long time. So very often they will take that charge out of the motor vehicle code and put it under the penal code, a misdemeanor, child abuse attempt or something. So that doesn't affect your ability to get an interlock.
I've said we could get a road officer to come over.
They've summoned one.
Yes.
So that allowed you back then to get your interlock. But so it does show as a child abuse, but it was Brielle the child that was in the car?
Mhm.
Oh my. Set for sentence March 30th. Is the PBT going to show alcohol in your system? Could. Now, you're not to use any drugs or any alcohol. The drugs include marijuana, which is lawful for adults to use for recreational purposes. But while you're on bond and probation, we prohibit it. You can take any prescription medication that's prescribed, anxiety medication, pain medication, antibiotics, whatever. You can take that, but unless it's prescribed by a doctor. And I'm serious. It's very, very difficult to just stop. If it was that easy, you would have already stopped. Now you got me hanging jail over your head, which is an extra impetus to stop. But you need to do something. You need to get back into AA. You need to get plugged in with somebody at Pivotal or somewhere else. Perhaps get some medical assisted medication. But you aren't going to be able to hold your breath. Now, what I have envisioned here, the prosecutor's looking for some substance abuse counseling. There's also the women's anger management program, which you're probably going to be put in. But you could get a head start on this by getting your counseling set up in advance between now and March 30th. We had some bumps in the road, I remember, but you did actually complete the program and graduate.
Yeah,
Yes.
it was because my creatine was always low, so which equals positive, and so I spent many a weekend at the country club.
Well,
and I found out that it is abnormal low all the time, has been for years. Still, I have a thing from every time I've been to Brunson Hospital, I had some surgeries, they've documented it, and it's always low. It's always diluted.
well,
Also from the type 2 diabetes.
and I don't know if we knew about type 2 diabetes back then.
No, at the time Sturgis Hospital said no, but I ended up going to Fort Wayne and
Because we did look into it. You kept having diluted tests, and we've struggled for the entire tenure of sobriety court with dilutes.
Yeah.
And we discussed this 10 years ago. Many programs, a dilute was an automatic jail sentence. Swift and Sure, some of the other ones, a dilute was just assumed to be an attempt to mask the results. And so we do a few, we do some sanctions, then there'd be jail, and then you get out. And I remember we had one guy in particular who we finally did discern he had a serious kidney problem. and he started to get treated for it. He did graduate. All right, we're waiting for local law enforcement. On Centerville and Constantine share a jurisdiction, so sometimes the Centerville officer's in Constantine. All right. I'm gonna ask you to step out with the officer, take the preliminary breath test, and then we'll send you out to the counter to get set up for your appointment for the pre-sentence investigation. I can remember things that happened 10 years ago. Just can't remember what happened yesterday. Very good.
Thank you.
Tracy, that's a good sign.
Your Honor, the drinking was more of like a binge thing. It was not a daily occurrence.
Well, you're binging to the point where you're almost killing yourself. So I don't want you to drink anything.
Okay. I just wanted to let you know that.
All right. But you have to develop a tolerance to be at the level 3s and certainly to be at the other level. So Jordan, I'll ask you if you take your client out to the counter, we'll get her set up for an appointment for a pre-sentence interview. The sentence will be March 30th at 10:30. Any treatment stuff you get set up before that, bring it, share it with your lawyer because I want to know about it. All right, thank you.
Great.
All right, Ms. Canfield, thank you for your help. We have an important appointment. Yes, well, we'll put that in the file.
Had it signed, we went over it anyway.
At 3 o'clock for Deputy Metz's wedding.
Oh,
Frank asked me if I would marry him on 262626.
all right.
All right. We will, Jordan, thanks for your help.
Thank you, Your Honor.
Who was the officer that came? I didn't get a chance to tell him thank you.
Oh, I don't
What was
know.
that?
Who was the officer that was here?
Deputy Raymond.
Okay, I didn't get a chance to tell him thanks. I will stop the live stream and we will be back.
In this intense preliminary hearing, the court tackles two major issues: a CCW firearm charge and a separate drug arrest case. In the first matter, the defense argues the gun found inside a backpack on the second-row floor of an Escalade was not within immediate reach, claiming there's no proof the defendant was carrying it under Michigan law. The prosecutor counters that the defendant knew the gun was there, requested the bag, and could easily access it, making it constructive possession. The judge ultimately rules there is enough probable cause and binds the case over for trial. In the second case, an officer testifies about spotting a known suspect, confirming outstanding warrants, and recovering suspected narcotics from a container inside a bag the defendant was carrying. Evidence tags and lab analysis were introduced without objection, moving the case forward. Do you think the proximity of the firearm was enough to justify the charge, or should it have been dismissed? Drop your thoughts below. Like, share, and subscribe for more real courtroom breakdown.